Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, in any given week, there is always a plethora of issues worthy of discussion. This week is no different. I want to begin by welcoming our viewers who are joining us on television in West Coast Berbice, region number 5. Welcome to another program of Issues in the News across the Berbice River, along the east bank of Berbice, all the way to New Amsterdam and Kanji. Welcome to another program of Issues in the News. And to those of you who are joining us on television on the Quarantine Coast, welcome once again to another program of Issues in the News. To our listeners and viewers who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. Last but not least, to the thousands of you who are joining us across Guyana, across the Caribbean, across Europe, across North America, and further afield on Facebook, welcome to another program of Issues in the News. And to our friends and followers on Facebook, please press that share button on your telephone, press that share button on your computer, press that share button on your iPad or whatever your device is, so that all your friends and all your followers can join this program and we can have the widest possible audience. Please share this program, press that share button so that your friends and your followers can join us in tonight's discussion. Rajesh Siraj, Anand Gangadin, Buli Puran, Norma Gayadin, Bharat Ramsuk, Glenn Dhani, Leroy Mangal, Taramati Dina, and so many of you who are on the Facebook Live. Good evening and welcome. Please ensure that you share this program so that your friends and your followers can join us. Please also include yourself in the program by posting questions, by asking me my views on any given matter in the comments section, so that we keep this program as interactive as possible. Any question that you would like me to answer, I will try my best to answer it. Any issue that you would like me to raise, please post it in the comment section of the live and I will attempt to address those questions. Freddie Lee, Abdul Haq, Francis Kunji, Kenneth Mahes, and all of you, welcome to another program of Issues in the News. I want to begin by extending Ramadan Mubarak greetings to all of Guyana, in particular our Muslim brothers and sisters across this land and indeed across the globe who are observing that very pious and great month in the Islamic calendar. It's a month of fasting, and our brothers and sisters across Guyana have commenced participating in this holy month. Ramadan is not only a festival, or rather an observance, that our Muslim brothers alone and sisters alone observe. Ramadan is also a national event in our country. And that is the beauty of a multicultural and a multi-ethnic society like Guyana. We have a multiple of religions, we have a multiple of cultures, we have a multiple of heritages, we have a multiple of ethnicities, we have a multiple of racial groupings, and each comes with their own cultural events, their own cultural practices, and their own religious beliefs. And our Constitution guarantees that right and freedom to every person to practice and propagate his or her political view, religious views, and religious practices and cultural rights. So, as we are observing the month of Ramadan, our Christian brothers and sisters are observing a period of Lent, and of course, that will take us into Easter. In the meanwhile, our brothers and sisters in the Hindu community will soon be observing Navratri and will be celebrating the festival of Phagua. Then we have, as I said, Easter. So in this 1 month alone, you have a kaleidoscope of religious admixture, a kaleidoscope of cultural admixture, a kaleidoscope of ethnic admixture, where all of our people will celebrate their respective festivals and observances in an environment of tolerance, in an environment of brotherhood, and in an environment of peace. These are tenets of our society that perhaps we don't take very seriously and we take them for granted. These liberties, these freedoms, and this type of tolerance which we are enjoying in Guyana is absent in many parts of the world. And people are still dying. People are still killing each other. Wars are still ongoing to secure these freedoms, these practices, these rituals, and these ethnic diversities that we are able to celebrate in relative tranquil and peace in Guyana. And we must reflect sometimes on how fortunate we are as a people to be able to celebrate all these different religious and ethnic observations and observances without any rancor and discord. And that is why when there are forces within our midst that try to create dissent and try to create disharmony and try to create racial animosity, we must stamp it out and stamp them out with full force. We are intolerant of those who want to divide our people. We must be intolerant to those who wish to plant the seeds of discord, dissent, and division among our people. Those are the enemies of our country, and they are the enemies of our people. So I thought that I'll begin on that important note that underscores and underpins our national motto of one people, one nation, with a common destiny. And that destiny is to create a better and unified Guyana for all of its citizens. And that is the national motto to which our government and our political party is welded and is committed to. So I wanted to begin with those very fundamental sentiments. Today, unfortunately, as you may have read in the news, the ongoing engagements between the Ministry of Education and the Guyana Teachers Union broke down abruptly. I cannot say that I am surprised. I am not a pessimist. On the contrary, I am an optimist. But when one party is operating in bad faith and is not sincere in any endeavor or engagement, that endeavor and or engagement will not succeed. I have already articulated on this program and elsewhere that from the 11th of August 2020, less than 2 weeks after we assumed government after the 2020 elections, our government, through the Ministry of Education, begun to engage the Guyana Teachers Union. And those engagements did not stop until the 31st of January 2024. That is the 31st of January this year. During those long periods, spanning from August 2020 to January 31st, 2024, the Ministry of Education met with the union almost once monthly, at a minimum rather of once monthly. And on occasions, they met as many as 3 times per month. During those engagements, dozens of issues raised by the union on behalf of the teachers were addressed by the Ministry of Education. In addition, the Ministry of Education, on its own motion, addressed another few dozens of issues, all which inure and redound to the benefit of teachers across this land. The teachers benefited annually from increase in salaries paid by the government to all public sector employees. And the teachers, through these engagements, enjoyed a regime of benefits which they all accepted and enjoyed arising out of these engagements. And then suddenly, on the 2nd of February, they launched strike action. At the end of the meeting, on the 31st of January 2024, the 2 parties had agreed that they will meet again on the 22nd of February. A date was fixed. There was a fixed agenda that was continuing to be discussed. And suddenly, abruptly, the union resort to strike action. That is why we have said, and I have said, that there are ulterior motives that are driving the union. As you know, the union took the government to court. The judge, despite my best efforts, ordered mediation. I had submitted to the judge, respectfully, that the parties can meet and resume their meeting without mediation. The judge expressed the view that he has powers under the rules of court to order mediation. And he did. The mediators met with the 2 parties, the government and the Ministry of Education, and after 2 days of engagements, the result was, coming out of the mediation, that the teachers were to go back to the school and the union back to the negotiation table with the Ministry of Education. The identical position which existed prior to the strike. So, in my view, nothing was really achieved. At the table, the government said, and in the mediation proceedings, the government made it clear that all matters are free to be discussed. The union, as I am told today, was insisting that the government begin to discuss salary increases prior to 2024, dating back as far as 2019. They want salary increases dating back to 2019. That is even before we got into government. The government's position is salaries can be discussed, but from 2024 going forward. The reason is more commonsensical than anything else. The government operates in a budgetary cycle. What is past is past. The government has no budgetary resources to increase wages for years that are bygone. The government can negotiate in good faith in relation to future increases. How can you ask a government in 2024 to negotiate wage increases for years prior to 2024? More importantly, when the teachers have already benefited from salary increases for those years, which they accepted unreservedly. And because of the government's pointing out to the union that we can only deal with salary increases in futuro and not in the past, the union broke the talks off. So they were going there, in my view, with the intention of breaking off those talks. Because I don't know which government in 2024 can seriously, after passing a budget for the year 2024, can seriously speak or rather negotiate for salary increases for years already gone by. So those engagements, as I have said and as you would have read in the news, have come to an abrupt end, unfortunately. I don't know what the next steps are. What I do know is that the case in the High Court is not yet completed. And the judge has ordered all the parties to put in their written legal submissions, and the judge has fixed the 20th of March, for the parties to present those arguments orally in the court. Many people seem to be of the view that the case is at an end or has come to an end. Not so. The case raises some important legal issues which I would like to see determined one way or another. You cannot leave these important issues hanging. There seems to be a view that persons can strike and withhold their labor, and the employer must still pay, although there is no labor or work coming from the employee. People seem to think so, that that is the law, that because you have a constitutional right And people think that it's a constitutional right. It's not. It's a constitutional freedom to strike. And if you choose to exercise that freedom, you have consequences that will flow. You have a constitutional right to free speech, but you cannot libel. You have a constitutional right to freedom of movement, but you cannot trespass. And I could go on. So some people believe that because striking is something that is legally permitted, then persons can embark on that activity without consequences, and they believe that that is the law. Well, that's not my understanding of the law. My understanding of the law is no work, no pay. If you choose to strike and you choose not to work, then the employer has a right to withhold your pay. If the law was otherwise, then people would be free to strike 365 days of the year. And an employer would be compelled to pay that employee for the entire year, although the employee has not done a day's work. Under which civilized system of law can that obtain as the law of a country? It cannot. It will turn the relationship of employer-employee upside down. So that important issue will have to be addressed by the court and settled in Guyana. Secondly, does a government owe an obligation in law to take union dues from workers' salaries and wages and pay it to a union? The government is not being paid for it. There is no contract by which the government has agreed to offer this service. There is no law that compels the government to offer this service. The government apparently has done so gratuitously, and you are telling me that there is a law that I must continue to do this as a government forever? If the government chooses to stop, there is some judge that will compel the government to continue to do something that it has no obligation to do in law or in contract. Well, that also will have to be settled. To me, these are very clear and simple issues, but they are misunderstood in this country, and we need either in this court or in some higher court to have these matters clearly settled. In my view, the law is clear, the law is settled, but obviously there are people out there who hold a different view. So we need to have these matters clarified once and for all in this country. So I am looking at your comments, and I am still looking for questions, but let's go on. Somebody is asking a very intelligent question. Say which country in the world workers are being paid and they are not working. And I don't know of any country. If you know, please type it in. Tell me which country on planet Earth workers can stay home or strike or don't work unauthorisedly but still get paid. Now, if you get leave to absent from work, if you get permission to absent from work, or you're absenting from work due to medical illness and you produce a medical certificate, then you will be granted leave. Those are acceptable cases where you will still be paid. but not when you are deliberately staying away from work. And you know what the law says and the textbook authors say? Strike actions are intended to harm the employers. Strike actions, as lawful as they are intended to harm the employers. I'm not saying so. That is what the experts have said. Therefore, on what rational basis, though you are committing a legal act, I must pay you for trying to harm me? You see, I keep saying that the law is a very commonsensical thing. The law is not based upon fanciful philosophy, or the law is not an aberration. The law is based upon reason and rationality. Anyone who is trying to injure me can never get me to pay them for that act that is intended to injure me. No law will compel me to pay in those circumstances. But all of those matters will be articulated before the court on the 20th of March. So I want to move on. So the issue regarding the hotel project that is scheduled to be built on 2 sports ground at Carifesta Avenue, Thomas Land, continues to be in the news. And again, you see the enemies of progress, the enemies of development surfacing all over again. These are the same grouping of persons who cut the Amila Falls project and denied the people of Guyana cheap electricity. These are the same persons who cut the specialty hospital out of the budget and denied Guyanese world-class health care. These are the persons who tried to kill the Marriott project when it was being constructed, but failed. These are the very people who tried to kill the Berbice Bridge project and failed. And I can continue to list projects that they have cut down, they have voted against, or they have criticized publicly, including the National Stadium. But we have pushed the agenda on in most of the cases. Again, you see the usual suspects: Hamilton Green, APNU, AFC, and their acolytes in the Georgetown City Council. They have made the unsubstantiated contention that the lands identified as the site for this project is owned by the Georgetown City Council. Well, my friend, it is very simple. Lands are owned in Guyana by 2 instruments, by one of 2 instruments. One, a transport, or a certificate of title. The Georgetown Mayor and City Council has been unable to produce either of these documents. They produced a transport which they claim relate to that land, but they have been unable to publicly demonstrate how it relates to that land. The Guyana Lands and Surveys Commission has done a detailed historical survey of that entire locality and have established beyond a shadow of doubt that those lands are owned by the government of Guyana. The last time I was in this program, I gave you the example of a case that I appeared for the government of Guyana to get an occupant, the Guyana Softball Association, get that occupant off that ground. And nobody challenged the government's ownership. The city council was part of that case as well. Where I saw the mayor saying that he will go to court. And I welcome that. Please, go to court. Show the court that you have a transport for that land. Or that the mayor and city council is the owner of that land by transport. That very transport that you're holding up. Go and show the court that transport relates to that land. Why do you think they're not going to court? The city council has a band of lawyers. They always had. Why do you think they have not reached the court yet? Today, I saw a press release from the city engineer saying that he has withdrawn a cease work order which was earlier issued by the city engineers department. How can you issue a cease work order against work that has not even started? Any person can go now to that site and you will see that there is no work. So you can't stop work when there is no work ongoing. That's the first thing. Secondly, the city engineer, to his credit, explained that that notice was issued in error because, firstly, there was no work ongoing, and secondly, he is not satisfied that the land is owned by the Georgetown Mayor and City Council. And he cannot stop any ongoing works on that basis, because that is the contention of the Georgetown City Council. On the contrary, the city engineer said that he is persuaded and convinced that the land is owned by the government of Guyana. In the historical survey of the entire locality done by the Guyana Lands and Surveys Commission, the Georgetown City Council owns lands that are south of Queen's College Compound. South of Queen's College Compound, there is a canal that divides those pieces of lands south of Queen's College Compound, and those are the lands, like Richard Ishmael, Critchlow Labour College, and those whole line of properties, those are the lands that City Council owns by the very transport that the mayor is holding up, saying that it relates to north of Carifest Avenue. They can't even read the transport that they have. All they need to do is hire a surveyor or a person who is trained in reading those documents, and they would get the advice that they should get. But I believe they know. But they are obstructionist. That is their nature and character. And that is why I began by describing them as enemies of development. And people must know that about them. And you must make a note, because they will come after your own personal projects soon. So I thought I would speak a little on that as well. I have been asked by the press to offer some comments on the election fraud cases. Now, there has been a worrying development. Defense Counsel lawyers for the defense are now alleging that a particular section of the Representation of the People Act is unconstitutional and affects their client's constitutional right to defend themselves in a criminal proceedings. That particular provision, Article 142, provides that no minutes or decisions of GCOM shall be admissible in any court of law. Now that has been there for the longest while. Never challenged before, but these bright lawyers have now decided to say that they need the minutes of GCOM because, based upon the newspaper reports, the minutes of GCOM shall contain or should contain a decision of GCOM to use spreadsheets to tabulate the results of the 2020 elections. And if the minutes say so, then Mingo was justified in using spreadsheets to tabulate the results. That is the argument as I understand it. And if the law prohibits the production of those minutes, then it deprives Mingo of his defense in law. And the Constitution says that he must be allowed to prepare and present his defense. So insofar as that provision in ROPA collides with the Constitution, it is unconstitutional. I've just outlined the whole argument there for you. So let's backpedal a little. These charges were filed over 3 years now. That's the first thing. Over 3 years now. The same lawyers have been retained and have been appearing for the last 3 years. First point. Secondly, the prosecution served statements on the defense over 2 years ago. So based upon the charge themselves, 3 years now, and over 2 years after statements were served on them, these lawyers must know and must have known what their defense will be. They must have known that. They have been talking to their clients 3 years now since the institution of the charge. They would have read those statements 2 years ago. So they must know and must have known what their defense will be whenever the trial starts. The trial went through its own tribulation before a date was fixed for trial. You have witnessed, as citizens of this country and as interested observers, you have witnessed the ordeal that had to have been undergone before trial dates were fixed. It took 3 whole years. It took many public exhortations and perhaps criticisms and lamentations before trial dates were fixed. When the trial date was fixed, then and only then the defense counsel comes with this objection. Didn't raise it for 3 years. Didn't raise it for 3 years. although they ought to have known it. So the first thing is the delay. As soon as the date is fixed for trial, the objection is made. Could not have been made 2 years ago? Could not have been made 3 years ago? Of course it could have. And these matters would have been ventilated and the trial could have commenced. But they waited at the last moment. Why? Because there is a deliberate strategy, if not a conspiracy, to delay these trials. That's the first observation I want to make. The second observation that I want to make is that when the happenings, but the occurrences which took place in Ashmin's building are publicly known. So I'm not talking any secret. They were broadcast across the world, on social media, on television, etc. One of the many complaints that were being made was the use by Mingo of spreadsheets. Riaz Holadar filed proceedings and went to the High Court to stop Mingo from using the spreadsheets. And the Chief Justice who heard the case made several injunctive orders stopping Mingo from using spreadsheets. I want you to listen to me carefully. Stopping Mingo from declaring the final results and directing that Mingo do the tabulation of the votes using statements of poll. The Chief Justice's judgment was broadcast live on Facebook and on the internet, widely carried in the press. So nobody can say that I am divulging internal secret information here. All this was streamed live. I appeared in the case, among other lawyers. The chief election officer was a party to the case. Mingo was a party to the case. Claudette Singh was a party to the case. They all appeared with lawyers. None of them ever said that spreadsheets were to be used. Let me repeat. Mingo never said that there was a decision of GCOM to use spreadsheet. Lowenfield never said that there was a decision of GCOM to use spreadsheet. Madam Justice Claudette Singh never said there was a decision to use spreadsheet. None. In fact, they all said that the statements of poll must be used as the basis for the tabulation of the results. So what minutes can now be produced to establish that a decision was made for spreadsheets to be used? Which minutes of GCOM can say so? When this particular issue was canvassed in the High Court. Why Riaz Holadar went to the High Court was because the spreadsheet was being used and not the statements of poll. So if there was a decision to use spreadsheet and not statement of poll, then Lowenfield and Mingo and the GCOM would have easily presented that decision to the High Court. They never did. And all of what I am saying are subject to affidavits and subject to court records. And the judgment of the Chief Justice was streamed live. The point I want to make is that this sojourn to the High Court under the basis of getting some minutes is another time-wasting exercise, because no such minutes can be produced now or credibly produced now. Had such a minute exist, it would have been brought to the court already. The third issue that I want to raise is that the magistrate decided that the constitutional issue raised by defense counsel will be referred to the High Court by a provision in the Constitution. So let me read the provision. It's Article 153, subparagraph 3. It says this: if in any proceedings in any court subordinate to the High Court, any question arises as to the contravention of any provisions of this Constitution, and they mention Article 138 to 151, and that is where the defense counsel is saying that those provisions were violated, are being violated. The person presiding in that court shall refer the question to the High Court unless in his or her opinion the raising of the question is merely frivolous or vexatious. So let me go slowly so that you can understand. If in any proceedings in any court subordinate to the High Court, the magistrate court is subordinate to the High Court, so there were proceedings in the magistrate court, so that applies. Any question arises as to the contravention of any of the provisions of Article 138 to 151, they raise an alleged violation of one of these provisions, the person presiding in that court, the magistrate, shall refer the question to the High Court unless the magistrate is of the opinion that the question is frivolous or vexatious. Well, the magistrate has ruled that the question is not frivolous and vexatious, and the magistrate said that she will refer the question to the High Court. The magistrate has to refer the question to the High Court. That was since the 6th of March. Today is what date? No such question has yet been referred to the High Court. My last check revealed no such question has been referred to the High Court. I am taking my time to explain these issues because many people are asking me questions, not appreciating that I, like a citizen like you, I am frustrated with the way the process is going, and people are blaming the government. The government doesn't try cases. The judiciary is independent, and we will never interfere with the independence of the judiciary, but we are free in the government to make our commentary, critical commentary as well, on the manner in which the judiciary is functioning. That's a right that we have, that's a right that you have, and we will exercise that right when we think it's appropriate to do so. You will note that I have not cast any aspersion, neither have I attributed an ulterior motive to any judicial officer. I am simply reciting what I know and what I recall as the facts in this equation. So let's move on. As you know, from June the 1st to the 29th, the International Cricket Council ICC Men's T20 World Cup will be hosted by and held in the West Indies and the United States of America. So that's a big, mega, global cricketing event. The ICC Men's T20 World Cup from June the 1st to June the 29th, and it will be held in the West Indies and the United States of America. At the level of the heads of government, at the recently concluded CARICOM Heads of Government Summit held in Georgetown, Guyana, several decisions were taken in relation to preparing the West Indies and the Caribbean region for this important tournament. The attorneys general of the region have been tasked with the responsibility of drafting the necessary laws to create what is called a common domestic space in the CARICOM region. So we have to pass a series of legislation that will allow for free movement and hassle-free transportation across the various territories of the Caribbean. And obviously, we have to go to Parliament, draft these laws, take them to Parliament, and have them passed long before June the 1st. We did a similar exercise in 2007 when the West Indies or the CARICOM region hosted the 2007 Cricket World Cup. So we are using as far as possible those legislation that we have used for that event. Persons in particular from Berbice continue to complain about the absence of judges in the land court in Berbice, and I'm pleased to inform you that the Judicial Service Commission today has commenced interviewing candidates to fill vacancies of High Court judges and land court judges. So today the interviews have begun. As you know, vacancies were advertised and many applications were received, and today the interview process begun to fill these vacancies. So those persons who have been waiting for an undue long period of time for land court judges in Berbice, the appointment process is ongoing, and hopefully we will have land court judges appointed first of all, and assigned to Berbice in short time. You would have heard a lot about the agreement between, or the arrangement rather, between Guyana, Barbados, and Trinidad and Tobago for the free movement of goods and persons, in particular food, and it was announced that a ferry has already been assigned to the exercise. I am pleased to announce that the company that will carry out this undertaking has been incorporated in Guyana. The name of the company is Carry Cargo Inc., Carry Cargo Inc., with its registered office in Georgetown, Guyana, and it comprises of directors from Barbados, Trinidad and Tobago, and Guyana. And this is the company that will be executing that agreement. As the heads have indicated, in fact, as President Ali has indicated, this is intended to be replicated across the Caribbean. It's Trinidad, Barbados, and Guyana are simply executing a pilot, and once it is successful, then the intent is to expand it across the region. I attended a very important law ministers meeting of the Commonwealth in Tanzania, Africa, and Guyana will benefit from a number of measures, a number of initiatives arising out of that meeting. A number of model legislation will be taken from the CARICOM Secretariat. Arrangements are being made for that to be done. And we will also benefit from a number of important model FIDIC contracts in almost every area of activity, including infrastructure, and I'm speaking about all type of infrastructural contracts like BOOT, EPC, etc. Then in the extractive industries, you will have model contracts. In the oil and gas industry, model contracts. In the gas LPG industry, you will have model contracts as well. And of course, these model contracts are prepared by highly qualified persons, and they are model contracts prepared for the entire Commonwealth. We will use these models and make the adjustments to ensure that they suit our peculiar circumstance and economy. But we will be saving millions and millions of US dollars were we to go out and retain the services of the quality of professionals that have been employed by the Commonwealth Secretariat to draft these contracts. So those are only a few of the major benefits that we will derive as a country from that engagement with the Commonwealth Secretariat. We have already exhausted our program time. I want to thank you very much for joining me in tonight's program. I believe that we have covered a number of important issues, and I hope that I have brought clarity to some of the issues that have been bothering you over the past week or so. I want to thank you once again for staying with me over the past hour, and I wish you all the best for the rest of the week. Stay healthy until I join you next week, and until we meet again, enjoy the rest of the evening and the rest of the week. Thank you very much.